All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated. Good morning and welcome after last Monday's hearing. Court officer, can you please call the case?
Good morning, Your Honors. This is case KSC BC 2020-04, Specialist Prosecutor versus Pjetër Shala.
Thank you very much, Madam Court Officer. Mr. Prosecutor, can you indicate who is present for the SPO today?
Yes, good morning, Your Honors. For the SPO, Line Pedersen, Susanna Guczynska, Federica Genovesi, Gaia Pergolo, and Filippo De Minicis.
Thank you very much. Victims' Counsel, you have the floor.
Good morning, Your Honours. I'm Simon Laws, counsel for the victims in this case.
Thank you. Defense Counsel.
Thank you very much, Mr. President. I'm Mr. Jelisen. You know the two co-counsel, Ms. Cariolo and Mr. Awini. He will be the acting one today. So you have our case manager, Ms. Janeta Petrovica. We have our assistant legal officer, Kaylin Chen, and two evidence review assistants, Juliette Healy and Judith Kolb, and of course, Mr. Shala, who is with us by video link. Thank you very much.
Thank you very much, Defense Counsel. Mr. Shala, can you confirm that you hear me well?
Yes, I hear you very well.
Thank you, Mr.
Gjykatësia, faleminderit zoti Shala. Sot do të organizojmë konferencën për përgatitjen e mbrojtjes.
Because I'm hearing not the right language. Okay. So, as said, we will hold the Defense Preparation Conference, which precedes the opening of the defense case pursuant to Rule 119 of the Rules of Procedure and Evidence. I recall that on Monday, the panel set out the agenda for today's conference. We ordered the parties and Victims' Counsel to file written submissions by Wednesday, so by yesterday. We received both on the 22nd and yesterday, the 23rd, written submissions by Victims' Counsel, which is filing 616, by the SPO. This is filing 617, and by the defense, filing 618. The purpose of today is to prepare the defense case. That's what we are going to do. We will go through the agenda set out by the panel. We will address some issues which arose from the defense, the SPO, or Victims' Counsel submissions. After that, you will be given the possibility to raise any issue you deem necessary to be discussed here. And then tomorrow we will issue a number of orders and give some directions in the afternoon at 2:30. Yes, before we start with the first item on the agenda, I recall that it's not necessary to repeat what you have said in your written submissions. We have taken note of them, and if you would require to go into a private session, please let the panel know, then we will proceed as such. Yeah. Okay, the first item on the agenda, that is the defense investigations. Defense Counsel, we understand that you still need to finalize some meetings with potential witnesses. And to be clear, are those potential witnesses that are not on your defense list of witnesses? And If that is the case, the panel would like to know what number we are talking about. And we also have taken note that these further discussions with potential witnesses will not delay the presentation of the case. So thank you. Defense Counsel, you have the floor.
Thank you, Your Honor. Good morning to Your Honors and to everyone in the courtroom and around the courtroom. Yes, Your Honor. So the main point is that we believe our final steps of investigations will not hinder or delay the presentation of our evidence. That's the main point to retain. In terms of the number of individuals we need to meet, unfortunately, there are a number of people that we wanted to meet before this block, and we couldn't. We are talking about potentially 4 different persons in 4 different countries. Yes, and 3 of them are in our list. One of them requires a meeting. We can give you the numbers if you wish, Your Honors. Yes.
Yes, please.
So I'll just go through the list just to give the pseudonyms rather than names,
Thank
Your
you.
Honor, so we can stay on the public hearing. The first one will be 4405. We couldn't meet. We have 4754, who unfortunately couldn't meet us because he underwent a surgery recently. We wanted to bring together here in the Netherlands a couple of individuals to be able to meet them, but that's not possible for health conditions, so we will need to travel to this individual, 4754. And we hope to do that in between this block and the next block. We also couldn't manage in our last mission during the recess period to meet with witness DW4, excuse me, Your Honor. Yes, DW405, who had personal circumstances. And the most important one, Your Honor, is DW404, which we could meet last year around autumn in Kosovo, but since then this individual moved to another country for medical reasons, and they seem to be heavy health concerns. So we need to at least ascertain or acquire a meeting with him to assess the level of health condition, because it has an impact. We don't have any statements from this individual, and to assess what we could do. As it stands now, we are thinking that the video link, if this individual is fit to testify, is the best way because of the difficulty to move for this individual. But since we had some information about the kind of medical concern he has, we will need to assess whether from last year until today his fitness to testify is not affected. That's why this meeting will need to take place before we move forward and inform Your Honors about how we proceed further with him. And as we mentioned, Your Honor, in our submissions, we are taking contact with some experts to deal with some of the victims' evidence presented, and we will be able to get back to Your Honors on that once we have established some contact and gave some assignment and got some advice from an expert. The plan as it is for the defense right now is that experts will come at the last block, so we are attempting to make sure that by that time, if we have expertise evidence on that matter, that will come in the last block. So nothing is delayed. But of course, as soon as we have documents and ascertain an individual's name, we would amend the list to reflect that in our list.
So you would provide us, with regard to the expert, with the report before?
As soon as we ascertain the individual, the report, any documents, of course, as soon as we have them. Your
And
Honor.
if we speak about experts, is it expert of experts?
As we stand, Your Honor, it's more about the economic part of the victim's presentation. We are trying to ascertain whether we need one or two to assess international standards, and if we can find, because to this moment we couldn't yet find somebody with the necessary qualifications in Kosovo to explain certain economic aspects proper to Kosovo. As soon as we have information, whether positive or negative, we can inform, even as a courtesy of the status. And if we have names and already assigned experts for that purpose, we will inform Your Honors. If we have a report, we will disclose it and we will amend our list.
Yes. Thank you, Defense Counsel. So if I count well, you have four, yes, these 4405, 4754, 05 and 04. You will try to contact them, and they are on your list.
Yes, Your Honor.
And then the experts, they are not. The potential experts are not on your list.
There will be a specific issue with 4405 that we might deal with later, because we have indirect contact. We have not established any contact yet with this individual, but we are hopeful, so we're making our last attempt to meet this individual. That will come probably later at the Rules 153 to 154 matter. Maybe we can explain later a little bit more in detail. Thank you, Your Honor.
Thank you, Defense Counsel. Very well. Mr. Prosecutor, would you like to raise anything in this regard? Madam Prosecutor.
Yes, Your Honors, good morning. We welcome the defense's clarifications with regard to the witnesses. Of course, one of the points we also sought clarification about is how many more witnesses, in addition to those listed, the defense was planning on in meeting. We would just request a clarification with regard to DW405, because it's not clear to us yet whether there was already a previous meeting with this witness or whether the upcoming meeting will be the first one, and whether, if the latter, also we would like to know, but this is something we will be discussing a little bit later, how the defense was able to provide the information included in the summary if there was no meeting before. That would be only our request for clarifications as to this point. Thank you.
Thank you, Madam Prosecutor. Defense Counsel, you have the floor.
Thank you. So DW05 is somebody we have met, and that is to be distinguished from W04405, which is originally an SPO witness. So maybe the numbers are the same, but DW4-05, which is number 11 in our annex, is an individual that we could meet, but we need to meet again just to ascertain a number of points of clarification. However, we have met him. That's the reason we provided the summary. This is what he is expected to testify on. And this individual, along with, if I may, Your Honor, DW4-02, have confirmed their availability for the second block, from the 2nd to the 6th of October, if I'm not mistaken. So it is more an internal meeting that we have with him to ascertain and confirm availability and go through probably a couple of details. But the expected testimony is the one that we summarized, and the availability is for the second block. I hope this clarifies.
Madam Prosecutor, does it suffice what we've heard now?
Yes, thank you. It does, Your Honor. Thank you.
Very well. Victims' Counsel, would you like to make an observation?
No, thank you.
Thank you. Very well. So no need for a second round, and then we can proceed to the second point on our agenda, which concerns the disclosure of the material the defense intends to present at trial, including the inspection of any tangible objects by the SPO and the Victims' Counsel. Defense Counsel, you informed us already by email last week on Friday, and also in your written submissions that you have completed your disclosure of the material you intend to present in trial, and also the tangible objects. Is there anything you would like to add in this respect?
No, Your Honor, that is the situation. We understand that everything in our possession that was necessary to disclose was disclosed.
Okay. I look at Madam Prosecutor. Anything to add?
Just to confirm that we have received disclosure of all items on the defense exhibit list.
Very well.
Thank
you. And Victims' Counsel, would you like to add something?
No, thank you.
Thank you. We take note of this too. Then we go to a topic that has already been mentioned by Madam Prosecutor, which is the prior statements and or the notes of conversation with witnesses. Defense Counsel, you have informed us that you have not taken any statements from witness 2, 3, 4, 5, and 6. So defense witnesses in case 4, 2, 3, 4, 5, and 6. And that you also have refrained from taking notes during your meetings with them. And I see you nodding. And what I read is that you're saying that this is because witnesses are fearful to come forward and to become involved. And we take note of that. But the panel would like to be informed some more, if you could develop on what the witnesses are afraid of. Because the fear, if I understood rightly, is not of such a kind that you are requesting protective measures. And a second question, which I would like you to elaborate on, is you provided us with summaries of witnesses, and some of them we don't have any prior statements, but only the summary. And I would like to hear from you how you were able to gain the information that they would be giving information on those specific topics. And this is not a sarcastic question, it's just to understand the procedure. And this is linked to a question I will be putting to you further on with regard to 2 witnesses of this group of witnesses, which we would like to have some more specific information on what they will be testifying, or at least that you expect that they will be testifying, in order to be better in a position to assess the relevancy. So, you have the floor.
Absolutely, Your Honor, and we expected that we needed to explain a little bit further. Well, fear is probably too general of a word, but what we have experienced, and I remind Your Honors, before we started the trial, we had an ex parte session where we explained the level of reluctance that we have faced with individuals to come forward and meet us, talk to us. We had occurrences where we have tried 4 or 5 times before an individual accepts to meet us. They were reluctant. They were asking many questions about who we are and didn't trust that. I think it is safe to say that they have a reluctance towards the institution, the process. Some of them, we had to clarify that they still retain the voluntary aspect of cooperating with us. And so since we don't have per se an obligation to take a statement, this was the best way to make sure these individuals show up, talk to us. and the more informal way we could do it with those individuals, the more chances we had of cooperation and maintaining cooperation. We have, I'm not going to go through all the struggles we had, but many individuals accepted to meet us, then refused, then delayed it, and obviously when you travel to a different country to meet somebody, it's very frustrating when you make a whole trip and then you don't see an individual, and of course we cannot force them to meet us because it's voluntary, it's cooperation, and so from what we have observed, that every time we hold informal meetings asking about what they know, what they don't know, without taking notes in front of them, that was what led us to be able to meet these individuals on a number of occasions and ascertain what they can help us with in terms of their evidence and their experience. The situations that we didn't take notes, but after meeting with these individuals, we summarized for ourselves what are the relevant points to us, which are sometimes discrete points, our specific points, and those show in the summary. If your honors have any questions on more specific elements to assess the relevance of an individual's evidence, we are happy from the experience. We are at least 2 or 3 at each time who have attended those meetings, and we are very open about what they are coming to testify about from our discussions with them. And we're happy to explain to the best extent possible what we expect them to say.
Okay, thank you, Defense Counsel. Madam Prosecutor, you have the floor.
Thank you, Your Honors. Yes, and we are also grateful to the defense for this explanation that, of course, we also needed a bit of background to the process in which they have collected the information included in the summaries. However, by reading the summaries, we think that there seems to be some additional information that the defense must have, that led to the decision to include certain witnesses in their list. And in fact, what defense counsel has just indicated is that they may not have taken notes during the meetings, but they had subsequently summarized the information. And we have noticed, for example, that in relation to DW406, the defense is calling him to testify about his whereabouts during the indictment period and explain why he could not have been at the Kukes metal factory at the time alleged by witness 4733. Now, it is our position that the defense must know the whereabouts of this witness and also must know where he was if he was not in Kukes, if they had decided to include this witness in their list. Similarly, there is no information as to the time in which DW404 was in Kukes. And again, this information must be known by the defense, otherwise the relevance of this witness's evidence is unclear to the defense themselves. Again, to the extent that the defense has this additional information, we would request that it be disclosed promptly to the panel and to the parties and participants. Of course, we are aware that Rule 106 establishes that internal work product, notes, and other internal documents must not be disclosed, but we think there must be a way to separate the, let's say, information of an evidentiary content in these notes from the information that, of course, is not subject to disclosure under the rules. We think that disclosing this information will enable the panel to assess, first of all, in a better way, the relevance of these witnesses, and of course, at a later stage, also their credibility by possibly confronting them with the prior statements or prior declarations they have made to the defense. but also, of course, will enable the panel to better prepare for the defense case, and finally also allow the SPO and Victims' Counsel to prepare for the cross-examination of these witnesses. So we believe that this is essential to enable an efficient preparation for the defense case and make the trial more efficient in itself. So these are our submissions on this point. Thank you, Your Honors.
Thank you, Madam Prosecutor. A clarification from our side. I heard two specific requests for information, for further clarification, with regard to victim 6 and victim witness 6 and witness 4. Is your request, is the request of the SPO specifically with regard to these 2 points, or is it broader? Because if it's broader, then allow me to formulate how I have understood you, and you may add to that or rectify, that you would like to receive with regard to the witnesses for which there are no statements available, only the summaries, the further evidentiary material available at the side of the defense, leaving out everything which has to do with internal notes. And I see you nodding now, and I think that you are going to tell me now that it's the second approach, but I give you the floor to formulate it. You would deem fit.
That is correct, Your Honor. We request that the defense disclose any additional information in whatever form it has been recorded, again, that is of evidentiary value, because we believe this will definitely help us and the panel and parties and participants to prepare for the defense case. We have also more detailed submissions about the sufficiency of the summaries provided by the defense in relation to a number of witnesses, as well as on the relevance of some of these witnesses. My colleague will comment on these points in more detail when given an opportunity. We thought that maybe the best place would be in relation to item 11 on the agenda. So we have a few further submissions in this regard. But again, coming back to the point of the disclosure, yes, we would request the defense to disclose any additional information they have received from the witnesses. Thank you.
Thank you, Madam Prosecutor. Victims' Counsel.
I'd like to support what's just been said by our colleagues in the SPO, please. It's been put very well, and I have nothing to add to it.
Thank you. Defense Counsel, please, you have the floor, and I would like to hear the view of the defense with regard to the request made by the SPO.
Thank you, Your Honor. Just to say again, the information that we have summarized and disclosed to the SPO. Maybe it's not evident for them as to what is the relevance, but I can go through the 2 individuals we have mentioned, DW404 and DW406.
Defense Counsel, for now that's not necessary. I would like to hear your view specifically with regard to the question if the defense has other material, other information available, that has evidentiary value, that has not been put in the summaries. That is the question for now. So if I would ask you, if I would repeat the question of the defense, to make it very specific, do you have in the notes you made after your meeting with witness 6 any additional information about the whereabouts of this witness during the indictment period? Is there, in your notes, more information about it? And with regard to witness 4, when was when was he in Koekes? No. Yes, when he was in Koekes. Yeah? Is there in your notes anything that is more specific? And I can add to that with regard to several witnesses, and if I say it by heart, I think it's on the defense witness list number 2, 3, 7, and 11. The question rose when we were reading, when was this witness specifically in at the Koekes Metal Factory? Yeah? You don't have to answer it, but I want to point out to you that based on what the summary provided to us, for us it was not clear, because the indictment period is a serious amount of time. So it remains very vague what then they have to say. So I will repeat my question. Is there any more information of evidentiary value in your notes that could be shared with us?
Yes, thank you, Your Honor. To answer the first question, the answer is no. We have put what is the evidentiary value from the notes we have. We can go through again and see if there is any more specifics, but if I take one of the examples, I can explain to you the decision making and why, based on not very specific information, we elected to call these witnesses, because it is obvious. If we take DW404, we understand that this individual was part of the Brigade 128, which is of interest to us, that this individual didn't see the accused in Koekes, which is of high relevance to us, which is the same case for a number of other individuals, and some of them have been interviewed by the SPO himself and said the same thing. So we elected to bring this kind of evidence before your honors. The specific extra element that we have on this individual, and I remind you that we saw him only on 2022 very briefly, and since then have been attempting to meet him again to clarify a little bit of timeline, a little bit of place and individuals. This individual told us, and we have put it, I believe, in the summary, that he was somehow charged of discipline, and that only involved the discipline of soldiers, which is relevant for us. The Brigade 128, an individual who was in charge of some task with a discipline could explain. So we are happy to hear this witness explain what is the discipline, and to oppose it to any other allegations, how that brigade functioned. If we go to other individuals from the same brigade your honors mentioned, it is the same. We understand that this brigade was positioned in another point 1. They had a different circuit where they end up in Burel at some point. We have explained that to your honors early before the start of the trial. That is where apparently whole composition or individuals that belonged somehow to the brigade, which was not very organized at the time, found themselves in Burel. There was an incident there, and from there they had a circuit where they went to the front, and that is important for us. As to the allegation of Mr. Shala being part of that brigade, having any role in that brigade, or being with the individuals that could be in the brigade, either in point 1 or point 2. That will be combined with a couple of other witnesses who were stationed in the Koekes Metal Factory and who saw Pjetër Shala one time or 2 times, or didn't see him at all while they were stationed. So we are taking 2 sets of facts, that is from the brigade, and whether members of this brigade know about Pjetër Shala, while they have had activity over a number of months up until the liberation, and individuals who are not from the brigade per se, but from the logistics. So we're stationed there spent nights there and didn't see Shala.
No, no. Thank you for this further clarification, but my question was that it is of relevance also when these witnesses were at the Kuko Metal Factory. When, and then more specific than during the indictment period, because that is a long period, yeah, or long is a relative word, but that would be a question which I cannot deduce from the summary.
Okay. For us, Your Honor, it's quite clear that they were there during the period of indictment because that's when the brigade started to form at point one, and then the whole circuit these members of the brigade made up to Burel, which is one of the incidents where we can put a date around 1st of May, I think, that they were away from Cooks, and then from that to the front. But if Your Honors want us to go through the summaries and try to find if we have any more specifics, this is the information that we have from those individuals that they were there when the mobilization started. So they came there at different points. We don't have any precision of dates, but we believe that this is exactly at the indictment period where people started gathering. Some of them joined before that, some of them a little bit later. But what we say is that those members that we call found themselves in Burel at that time, and then went to the front.
Yeah. What I hear now, I hear you explaining, yeah? And from your explanation, my impression is that there is some more information available in the notes that gives more body to the summaries. That is my the point I'm trying to make, and I think that was the essence of what the SPO, supported by Victims Council, was doing. So, and I already heard you say that. And my suggestion would be that you that the defense goes through the internal notes again and tries to take out as much as possible to and add that to the summaries, because apparently you already now know some more than we know, and by explaining it to us, you're already giving us some more information that apparently is available.
Yes, Your Honor. And the situation is this, Your Honor. We are satisfied if you want us to put a little bit more detail for what we understood from the witnesses.
Not a little bit more. My question would be everything, yeah, that you think, that you assess, because that I leave it to you,
yes,
that is of evidential value, yeah, for if we would allow to call the witnesses, to hear the witness, both if it's about what happened, so in terms of fact finding, and also in terms of assessment of credibility. That would be the request.
Yes, Your Honor, and that's exactly the point why we only put what we are sure about where the witnesses were specific. So when we understand that when the individual tells around the mobilization, maybe before, maybe after, if we put dates or months in the summary, then it might look unfairly that there is a contradiction where the witness tries to explain it in the court. So we can put the dates that we believe or the periods that we believe match from what we understood from the individuals, but that shouldn't count as what the witness told us precisely, because they might have a different recollection at that time. But we are happy to go through and explain the periods. But if we put in a summary and then one of the individuals say, well, it's not March, it's February. It's not because he made a mistake. It's because when we met with them, he said from the beginning, or when they made the general call for mobilization, or say we were in the brigade from the beginning, or where there was point one, for us was sufficient to establish that they were from the beginning of the collection of individuals leaving Kosovo into Kux. And that doesn't affect per se the relevance of those individuals for us, because they were part of the brigade at the time there was the events in May in Burel, and then the front, the bombing, and the most important aspects of the indictment period. The day they joined should be taken then with a lot of margin.
Defense Counsel, our direction would be, because we have been discussing this, the direction of the panel would be in this regard, that you should only put in the summary, what you can refer back from what the witness has told you. So if you cannot say a date, because you don't know, please don't put anything in it. That is for sure. It's referring back to the panel and to the SPO and Victims Council, what you have heard about from this witness, what he will be expected to testify on, because it should come as close as to what he has said to you.
Very well, Your Honor, and we welcome that direction, because that doesn't put us in a situation where we put things in the mouth of a witness where it's not clear for them. So that's why we refrain from putting any specifics where there isn't from those individuals.
But at the same time, we should be able to assess the relevancy, and I leave it there.
No, we understood, Your Honors, and we will go through again our summaries. Any relevant, probably factors as to period, even without the utmost specificity, we will try to put it as clear as possible, because the defense situations, we're trying to put everything that is relevant. We're not hiding any aspects. We're not taking anyone by surprise. It's just that the situation, more than 2 decades afterwards, where we can't push for memory exercise with those witnesses, led us to satisfy ourselves with events that refer us to the period. So we will go through the summaries again and see if anything of evidentiary material as to times and places is there, even in reference format, referring to events. We will put it. We will put it. Thank you, Your Honor.
I will do a second round, but I would also like to thank the defense team for providing us on a rolling basis with the courtesy copies of the summaries. That has been much appreciated. Yeah. Madam Prosecutor, is there something you would like to add in this respect?
Your Honor, again, we have specific submissions on the relevance of the witnesses. We welcome the directions and also the clarification. We appreciate the difficulties, but also the defense, we believe, should know what the witnesses are expected to testify about, especially when it comes to time periods, again, to be able to assess the relevance. But I will leave it at that for now. Thank you.
2 points. The observations the SPO has with regard to the witnesses on the defense witness list, when we will be discussing the defense witness expected testimonies after the order of the appearances. I can give the floor to the SPO then to comment on the different witnesses. Yes. Defense Counsel, by when would you be able today, I hope, to provide us with the additional information, because it's of relevance for our decisions, our oral orders we have or we intend to give tomorrow. So we would appreciate very much if you could give us the updated summaries by the end of the day.
Yes, Your Honor. The only hurdle is we have the big Rule 103 filing to submit today, which engages a lot of the resources, but we will do our best, again, to supplement any of the summaries if we have extra information by the end of the day, Your Honor said, I think.
Okay, the 130 rule request. Yes, but this needs to be done. I would say, and I welcome very much if you would first provide us with the summaries, and if the Rule 130 would come in tomorrow, which we hope it won't, but there will be some leniency. But we have to, on this point, we have to proceed, and I have to give the defense, the SPO and Victims' Council the possibility also to react on this additional information, and that would mean that we would be asking you to comment on it when it comes in, and by somewhere tomorrow morning. Tight deadlines, but tomorrow we are in court, and I think it's important, with a view to the planning of the defense case, which we would like to start the 18th of September as planned, that we take care of how we are going to proceed by tomorrow.
If I may, Your Honors, the submissions that we intend to make about the relevance of these witnesses will be of guidance to the defense, as well as to what additional information we think is required in order for a proper relevance assessment to be possible.
Good, thank you.
We have a suggestion, Your Honor.
Defense Counsel, you have the floor.
Thank you, sorry. Would it be possible for us to have the leniency to submit our Rule 130 motion, which is due today at 4 by midnight, and then we can give utmost priority to the summaries, because we are at the stage where the part of the team that is assessing the evidence and footnotes, the evidence, is the one that is dealing with the summaries, so we can offload better summaries as soon as possible, and then we have a little bit of the evening to finish with the Rule 130 motion. So rather than 4 at midnight.
Yes.
Yeah.
Let me have a small thought about deadlines, but yes, I think that could be a solution. For now, I will continue with our Victims' Council. Is there anything that you would like to add in this exchange of views?
No, thank you, Honor.
Very well. Yeah. We will now go to the order of appearance of witnesses. But yes, with regard to the 130 rule request that will be is due today, if we would, in that respect, shorten a little bit the deadlines for the SPO and Victims' Council, would that be possible?
I understand Your Honor means the time for us to respond.
To the one, yes.
Yes, well, Your Honor, of course we want to be as cooperative as possible in order to be efficient. It depends on what motion we're talking about, and the length, and then the complexity, but we will...
You will endeavor.
We will endeavor, certainly.
I think that for now that is
yes.
enough. To the impossible, nobody is held, so... Victims' Counsel.
Yes, our position is the same. Of course we will. Thank you.
Now, thank you for this cooperation spirit. Thank you. I see you standing, Defense Counsel.
One further suggestion on the Rule 130. By the time we submit it, we might provide courtesy copy for everyone, pending the official distribution on the following day, so they can have them first day, the next day, pending the distribution.
Yes.
Although CMU has been very great in distributing before opening of business on the next day, but if that helps, we can do that.
The deadlines won't change. It's just that you have a little bit less time because it's coming in later. That is where it boils down to. Very well. Let us go to the next point, the order of appearances of witnesses. And specifically that the defense envisaged to call during the 6th and the 7th everyday blocks which witnesses. Now, we noted, Defense Counsel, that you envisaged to call only one witness for the 6th evidentiary block, that would be witness 6, and only as of the 20th of September. And I think that you can imagine what I will be saying now. I recall our repeated directions to all parties and participants that to the extent possible, of course, and foreseeable, that the courtroom should not be left unused. We feel very strong about this, as you may understand, and we only have limited time in court because we have to share this courtroom with other panels, and this is the time we have, and we should use it to the best of our possibilities. And an important other reason, which I don't have any doubt that is on the front part of your mind, is that we have an accused in pretrial detention, and we just want to keep up a real serious pace. So my question to you would be, would the defense be in a position to call a witness already for the 18th, another witness? And as a follow-up of preceding that question, have you made any efforts to call a witness for the first 2 days?
Thank you, Your Honor. We appreciate the need to fill the court days, and we were working towards that to be able to start. The initial date we wanted witness 6 to appear was the 18th, but we were faced with his medical problem. He has promised that he has a medical examination on that day, which changed our schedule. On, I think, the day before we submit our list, he committed to travel by land to be able to attend, but we don't have yet his date of arrival. He said he would be willing to travel even on the 18th at night, but he's...
But I see your point,
yeah.
and I have no problem with starting on Wednesday with this witness, because I leave the plan, or even on Thursday, I leave the planning
Okay.
in principle to the defense team. However, I don't want to be, I don't want to have one witness in that week only, because it means that a part of the week we will not be using the courtroom. And I have seen a number of witnesses. We have 17, and I know you have some. You will be introducing some requests, so we will not be, if we allow for them, not hearing them all here in court. But still, that week should be used, I hope, more efficient.
Yes, Your Honor. We couldn't place the 2 witnesses of the 7th block, that is the 2nd block of the defense, before, because we are fearful of visa and passport issues, and that's why we used the European citizen to start. There is one possibility for a witness that could fit in 1 or 2 days, and that is, if you allow me, DW404, who is available, but at this stage we don't know what he requires in terms of logistics. What we can promise is that we can try our best to possibly have him to fill, even through starting DW 406, but we cannot promise that this will be successful, Your Honor. It is unfortunate. This is the best that we could do to, you understand, Your Honors, that in the 17 witnesses, only a few we have really control of how to present them ourselves. And so that's why we started with 06, and then the 2 witnesses, and then the 2 logistics. We have 3 days of hearings on the 23rd of October, in which we suggested to put 01. Our plan was to make sure that when we put them on the block, that we make sure it happens rather than have any surprises. But we can try, Your Honor, to fill those 2 days. Okay. And we can inform you if we are successful.
And if I may suggest, I heard you saying problems with passports, visa. You can also try to bring them before. I mean, it's not said that it won't work out. I mean, if you hear tomorrow, by tomorrow the panel will decide in principle. I mean, things can always happen, but in principle tomorrow you will hear what our views are, and then you might try to press a little bit to see. But I leave it to you. This is our direction to endeavor. Yes, Defense Minister Gillissen, Mr. Defense Counsel, you have the floor.
Oh, I'm sorry. One of the real difficulties is that we are not judges. We are not prosecutors. We don't have any police. And for these people in Kosovo, that's very important. They are more than reluctant, really. And so even when they accept to, may I say, deal with us, they feel themselves very free. Sometimes we have some meetings. They don't come. The last one, we had a meeting. We were in Pristina to see this guy. And the day when we arrived, he said, I'm sorry, I have a wedding. A wedding, please. We have a meeting. A wedding with my daughter. So you were aware. So that's this kind of difficulty we faced. And you can trust me, we tried a lot, really a lot. So they fear, that's sure. They are fear. They are reluctant. So that's really a very diplomatic business, very difficult one. And we already tried for the first block of the defense presentation of proof to have a second one. We will try one again, but you can trust me, it's not absolutely not a choice. That's really very painful.
Thank you for this further clarification. With regard to the visas, I would say please liaise with the registry. If they can be of any assistance, I don't have any doubt that they will do their utmost if they can.
Yes, thank you, Your Honor. On that point, we have already sent the forms that are necessary to the registry, and we will be, after these set of hearings, really working on that aspect to make sure everyone is ready on the dates. And again, like Mr. Gillissen said, we will try once again. This is the only individual, DW 401, that could fit in 2 days. And if we can acquire his availability for those 2 days, we will not hesitate. It's the common interest to go as smoothly as possible and to fill all the days. Thank you, Your Honor.
Thank you. Now, then we go. We continue. We will now discuss the expected testimonies of the witnesses proposed by the defense. And Defense Counsel, we are now in public, and I foresee that we will be going through the list of the witnesses. I think, we might better go into private if you are going to enter into details, or if you say no, I can discuss everything in public with regard to the different witnesses. Then it's good for me too. But I wanted to have your view on this.
Your Honor, we can start in public, speaking logistics and facts. That doesn't identify anybody. And if there is need for more specifics, then we can group specific topics and address them in private session together, if you honors agree.
Very well. What I will do is I will start first with a round of the SPO and Victims Council. Madam Prosecutor, or Mr. Prosecutor, I think it was you who was going to give some further observations with the assessment you think, the information that was lacking for a further assessment of the relevancy of the witnesses.
I understand, Your Honours, direct to the defense that we will now be going through the list of witnesses one by one, and if that's the case, then we can respond to the defense after if they are going to make additional relevant submissions about the witnesses. We can respond to those, or I can lay out now our observations concerning the witnesses on the exhibit list. Not about all of them. For some of them, we have no observations.
I think it would be useful to do it like that, because that could be of assistance for the defense when going through their notes. And furthermore, while you are talking, I have here our lists with questions, and we will see where it coincides in order not to double.
Very well, Your Honor. Just 1 second.
Defense Counsel, coming back to the points we have just discussed with regard to bringing in the witnesses and the difficulties you are facing in terms of time. You could also consider, if the visa doesn't work out or the passport is a problem, to see if there's a possibility for a video link hearing. I mean, if they are available, they are willing, you know where they are, we have seen that a lot is possible. So I give that as a suggestion too, that might resolve some possible problems.
Yes, Your Honor, that's why DW401 is our best chance of filling 2 days, regardless of those logistical issues. We will try that.
Very well, thank you. Mr. Prosecutor, I used the time just to discuss this little point with the defense. You have the floor.
Thank you, Your Honor. Your Honors, Rule 137 states that the parties shall submit evidence relevant to the case. And pursuant to Rule 143, paragraph 4, the questioning of a witness must be effective for the ascertainment of the truth and avoid undue consumption of time and resources. It's our position, Your Honors, that based on the information received so far, that a considerable number of witnesses proposed by the defense is irrelevant, or their relevance cannot be assessed without the provision of additional information. For some witnesses, the information is so scarce as to prevent any assessment on whether they may have any relevant information on the charges. Other witnesses were not, based on available information, at the Cook's Metal Factory at the times relevant to the indictment, who are supposed to testify about events which took place long after the end of the indictment period. Finally, the relevance of certain topics the defense want to elicit is unclear, and we request that it be clarified, if need be, by clearly laying out what the defense case is and how these witnesses are relevant to substantiate it. I will start with the first witness. I will only list the witnesses that we take, the relevance of which we want to take issue now. The first one is number 2 on their list, a witness 4454. Based on available information, which consists of SPO statements, the witness was not at the Cook's Metal Factory during the indictment period. We understand that from our statements that he went to Burrell at the end of April 1999, where he stayed for about 2 weeks. In mid-May, he returned in Cook's, where he stayed about a week, but he stayed at Pavilion or Point 1, which is a location far from the Cook's Metal Factory, perhaps somewhere between a few hundred meters and a kilometer. And according to the witness, during that time, which is the indictment period, he did not return to the Cook's Metal Factory. So we object to the relevance of this witness without the provision of additional clarification as to what evidence the defense want to elicit. Number 3 on the defense witness list, which is DW402. From the summary provided by the defense, Your Honors, this witness appears to have only been at Pavilion 1, again, not the Cook's Metal Factory. Therefore, his ability to testify about the alleged crimes, which we allege took place at Pavilion 2, is unclear. Considering the circumstance, his expected evidence that he did not know the accused is also not relevant. Now, the defense wants to elicit evidence from this witness about the KLA organization in Cook's. But to us, the relevance of that defense, or the evidence for the defense case, Your Honors, is not clear. The prosecution bears the burden of proving certain contextual elements. But why is this relevant for the defense case? And the same goes for the movement of Brigade 128. That's unclear at this time. So we would request at least clarification of the relevance of that information for the defense case. The other witness we take issue with is number 7 on their list, DW404. There is no information, we've already touched upon this, but no information whatsoever on when this witness was in Cook's and where he was. Whether Pavilion 1, Pavilion 2, was he there at all? Thus, the same considerations we shared for the other witnesses apply to this witness. And in this regard, Your Honor, we submit that defense, before calling a witness, they must know where the witness was and what evidence the witness, therefore, is able to provide. We don't accept submission that we don't know, we're not certain, we don't want to write it because we might be wrong. If they don't know that the witness is able, because he was there, to provide relevant information, then we question whether this witness should be called to testify at trial. But we're not going into to see if we're lucky enough that the witness has relevant information to provide. The defense should know that, and if need be, they should contact the witness and elicit this additional information and amend their summaries accordingly. Now, with regard to witness number 12 on their list, who is DW406, as already said by my colleague, we do need more detailed information about what his whereabouts were at the time. We can't wait for the witness to tell us at trial. It's a matter of fairness and not the quality of arms. We believe that the defense must have discussed the witness's whereabouts at the time and that that they must be in possession of this information. If they're not, we ask the defense to reach back to the witness and ask to provide this information. Also, general statements like the witness will provide relevant background information about the context of the charges are too general to appreciate their value, Your Honors. Finally, the issue of the alleged fabrication of cases by the Serbian Secret Service is absolutely not relevant without further explanation by the defense. We just simply don't understand what this witness will testify about and how it affects the charges in this case and the evidence presented so far by the SPO. We also object, Your Honors, to witnesses number 14, 15, and 16 on the defense list, the 3 internationals. The defense wants to elicit evidence about events which happened well after the end of the indictment period. And in this regard, Your Honor, because it may be efficient to deal with it now, our objection to the relevance of the 3 internationals proposed by the defense also translates into an objection to their request to amend the exhibit list with a number of exhibits pertaining to these witnesses, the relevance of which, Your Honor, is not clear. One exhibit does mention 2 victims that the SPO alleged were detained in Kukës, but its report that concerns the whereabouts of these witnesses
were they throughout the indictment period at the Kukës metal factory, and when precisely? And I think we had some overlapping questions, but I think if you want to react, then you have the floor, of course.
Thank you, Your Honor. Thank you. We heard the SPO colleagues puzzled by the scarce information. We're puzzled also by the scarce information they provided in their case, and we're trying to respond to that. We have clearly said that Mr. Shala was accused, and they mentioned in their PTB that he was part of the Brigade 128. We are bringing the Brigade 128 to tell us that Pjetër Shala is not part of that brigade. We are bringing people who were stationed in the KMF to say that they didn't see Shala there. So we are responding specifically to the allegations that Shala had any kind of authority, moral or titles or anything in the Kukës metal factory that would have allowed him to enter any agreement with any other individuals to commit crimes. That is very clear, and this is the reason why we bring people from the Brigade 128, even if we don't know everything. As Mr. Gilisen said in the opening statement, Mr. Shala had no place in the Kukës metal factory, and there was no place for him. And this is what we show. We are not shying away. And you will see, Your Honors, that most of the witnesses are witnesses interviewed by the SPO. This is precisely why we ask for them to be called, because we want the truth, and we want to show that this information existed when the SPO chose to formulate their charges. This is the utmost relevance to this case. We have one individual who was there, who said from the beginning I was there, from point 1 until liberation, and he will explain what the brigade and the people who were with him were there, and we have listed him, and that he is number 3, Your Honor. And he will explain, and we said it in the summary, what is this makeshift clinic that we sought clinic in the officers' building, and that we believe is very relevant to see the level of basicness or basic facilities that they were there at the moment. We are bringing somebody who had a role in discipline, and we're satisfied that if we call this person, he will explain that he was part of that brigade, and that brigade formed before the general mobilization and ended in Prizren and Natchez after the liberation. Everything that happens with this brigade is relevant, and we are there, even if we don't have all the information, to have them here and ask them questions, because we are confident. And my colleagues say it's not important that somebody doesn't know Pjetër Shala. When they were there or in the brigade, they knew the members of the brigade. And that's also the case for the deceased person, number 17. One of the key points for number 17, even though he speaks about other elements, is that he was not even asked by the SPO about Pjetër Shala. The head of the brigade wasn't asked about Pjetër Shala. There was a document signed by one head of ministry, and he denied the authenticity of that document. And we didn't call that witness even through documentary, because the SPO has given up on the authenticity or veracity of the content of that authorization that supposedly made Pjetër Shala go to Cooks. So we are addressing the allegations of the case, saying that Mr. Shala's job was not in Cooks. He was in the front fighting for his nation. He was not there, didn't have any role there, and we have stated clearly the case of Mr. Shala when we needed to. The other part is the logistics, individuals that were withdrawn from the SPO. There is one person who has the only live footage of what was happening there at that time, and we are calling them. And there is one person who was all the time there and had an encounter with Mr. Shala at that time, and he will explain in which context and when he saw him and when he ever saw him again. So this is of the utmost relevance, Your Honor. The other individuals like DW401 responds to specific allegations that we have submitted in cross-examination, and just by the name, Your Honors will have the specific topic, and that individual will address that point. As to DW406, we have the relevant information and we shared it. This person, who was alleged to be in Cook's Metal Factory amongst some high officials, because the witness who mentions this individual and almost all the political elite of Kosovo at that time in Cook's trying to beat him, that is W4733, we have one individual here who was not at all in Cook's, and we have disclosed 2 certificates that show that he didn't enter Albania. This is sufficient for us, and this is relevant for us. And this is something that we will show combined with number 6 in our list, W04441, and number 10 in our list, W04440. Those individuals have been mentioned as having a role, criminal or not, in the Cook's Metal Factories, where these individuals never set a feet in Albania or never set a feet in Cook's at all. This is relevant, Your Honor, for the credibility of those witnesses, and we are entitled to respond. We are not calling all of them live. We are putting their statements. We didn't have contact with them, but what they have said to the SPO is of high relevance for the duty of the SPO, the charges they are squaring against Mr. Shala, and for our response to the credibility of those witnesses. If I come to the internationals, it is very important, Your Honor, and we made the submissions at a certain time during cross-examination to explain that we will bring documents about the specific event, and this relates clearly and directly to the credibility of individuals and stories we heard that happened. and it was the intervention of many factors that led them to be liberated with their braveness and effort, but the level of organization is not the one that supports a regular army like the Serbian army had. And that is one of the key aspects. Some of the individuals will come and testify about the circumstances. And this is one of the main points that Mr. Gillison in his opening made. These are the victims. These are the tortured ones. These are the expelled ones, and they had to fight back with scarce means. And that is the situation, and in that context, that need to be said and done for the Republic of Kosovo, that we set this context when we're talking about charges. And that will explain what the case of Mr. Shala that has been put is about. It's not about going after fellow nationals and beat them and punish them. It's not at all about that. And if somebody did it, they did it on an individual basis. Yes, Your Honor, my last point is about equality of arms. It is the equality of arms that led us to put those documents, because we didn't meet these people. Some of them refused contact with us. We know they are relevant. Some of them are mentioned in the PTB of the SPO. It is the equality of arms that we don't have to go and play poker with individuals who refuse and sometimes are hostile to us. We put their statements. So, Your Honors, if you don't take them for the veracity and truthfulness of what is in the statements, at least you know what is the information that has been provided to the SPO, and you have to take it into account when you are judging Mr. Shala. Those individuals are put under those rules because we don't necessarily need to go through and prove elements. There are relevant information as to Mr. Shala or contradicting certain allegations contained in other witnesses' evidence that were admitted through documentary fashion, and that's why we are putting them under those rules, for Your Honors. We believe this is the most efficient way to do it, and we are happy if Your Honors say, no, they have to come, but we don't have access to them, and that's why other rules will have to come into play, but we are not shying away from anybody. We see what is in the statements. We want them part of your assessment, Your Honors, when you reach a verdict, and we are happy. The rules allow it. We can make requests if necessary, if you need to have them for cross-examination, so the SPO can explain why they didn't call them, or for other reasons, or even testify live fully. But we will have to go through Your Honors if we are going there. Thank you, Your Honor.
Thank you. In my notes, I see that all the different items have been responded to, but just to be sure, I look at Mr. Prosecutor. Are all the points you made answered?
No, Your Honors, they're not.
No, they're not?
No, they're not, because we...
I meant to say touched upon.
Touched upon, yes, Your Honors, I think by and large. Answered, I don't think they were. If Your Honors would like to hear a short reply, perhaps on a couple of points, I would be happy to. If Your Honors have heard enough, then we...
No, I would like to have a further reply, and what I did not hear was an answer to our questions. So I invite you to come back to that. And then, sorry, Mr. Prosecutor, I will give you the floor to give some further submissions. Because Defense Counsel, I find it very important to talk this thoroughly through, because we want to give you all the space to present your case, but it's useful to give it some further clarification on some points.
If you allow me, Your Honor, just to return to your question, Your Honor's question.
My question was, were the witnesses during the indictment period at the premises of the Kuko Metal Factory, and if you can even be more specific, not a general remark, but if you have more information, when they were there.
Yes, Your Honor.
And then what I mean is, we know that, or at least evidence has been brought to us that there have been discussing several places where the KLA apparently resided, but we are specifically talking about the Koekers Metal Factory.
Yes, Your Honor, and this is one of the reasons we've always submitted that Your Honor should go to the crime site to see those 2 points, because it will make it clear. To respond to Your Honor's question, when we have those individuals who joined the KLA and the Brigade 128 from the beginning, they were at point A because point 1 was the first one operational. And from that time on, we have their circuit of passage, and they were at the Koekers Metal Factory occasionally. Those who were stationed at point 1 with the brigade are there. It's very near, and they can explain that the soldiers from the brigade are there, and they went from there to different points. One of the individuals, as you see in the summary, and that he's number 3 of our list, DW402, explains that he went once to get a bandage. So that's when he made it to the point 2, that is the fabric, that metal factory. So their entrances, occasional ones, in the Koekers Metal Factory are depicted.
Yes, but I'm not talking about the occasions. I'm talking about time frames. That is the panel is interested in time frames. If you have those, that was my point.
If we can give a general time frame, those individuals from the brigade were there from February before the general mobilization, let's say, at different times. They were there from the general mobilization or upon general mobilization, and I take the example of E042, who came from Germany at the time of mobilization. So that is the time frame, and made it to Koekers. That's the time frame.
Okay, Defense Counsel, I think I'm not making myself clear. The panel would like to know, with regard to witness 2, 3, 7, and 11, if you can say more specifically, during the period of the indictment, which you state that apparently they have been there at the Koekers Metal Factory, if you have more specific time frames, if you can, if those witnesses can say, we were there around the 20th of May, or we were there around the end of May, or we were there the 5th of June, or we were there the 10th of... I mean, that is what my question turns around.
Yes, Your Honor, and we promise to go through and be as specific as possible with any more precise time frames, but the only references we have is general mobilization, that is end of March, sorry, and from there onwards they can explain a week, 10 days, and that's the way probably we can figure out. And then the other point that is of essential, where we have a date, is Burel incident, so that gives us references between mobilization and then the Burel incident for the Brigade 128, and then the Operation Arrow, where that brigade went to the front in Kalimash. So those are the general specifics that we worked around. If we have any more specific notes, we will provide them in the summaries for Your Honors.
Very well. Mr. Prosecutor, I see that it's 11 o'clock. With my further clarification question, we come at the moment of the break. We will continue, and then I will give you the floor for the second round. The hearing is adjourned for half an hour.
All rise. All rise.
Please be seated. Welcome back. And let's proceed. I see that the the SPO composition is the same. That goes also for the Victims' Council. And I see some colleagues missing for the defense.
Yes, Your Honor. Ms. Kalin, Ms. Kolbe, Ms. Juliette Hilly have left the courtroom for this session. Thank you.
We were at the point that you had given us some further clarifications with regard to our question regarding witness 2, 3, 7, and 11. And I now give the floor to Mr. Prosecutor, so for the second round. You have the floor. Thank you.
Thank you, Your Honor. Some of the witnesses discussed by defense counsel during their submissions, we have not taken issue with them or with their relevance, so we won't be replying. We'll just be replying to 2 or 3 points. The first, Your Honor, is the issue of the internationals. If the defense believes that any of their evidence contradicts the evidence of specific witnesses in this case, or part of their evidence, then we request the panel to order them to specify what this evidence is, both with respect to the witness in question, the witness called by SPO, whose evidence they want to contradict, and to the evidence of the international. So what part of this statement of witness you've listed contradicts the evidence called by the SPO, and how does that support your case? Because, Your Honor, we repeat, we could not determine that, and the defense have failed altogether to sufficiently substantiate the relevance of these witnesses, even in their response. And statements like evidence on the general situation will help understand what is true and what is not, as counsel stated at page 42 of the transcript, are really unhelpful. They're just like a general statement which does not substantiate the need to call these witnesses. But of course, we welcome further submissions which meet the required degree of specificity so that we can reply and Your Honors can make an informed decision on that. As things that stand now, these 3 witnesses have no place to testify in this trial at this time. The footage of the funeral. We really, at this point, we don't understand what the relevance of the footage is, most of which happens outside, the vast majority of which happens outside the walls of the Cookers Metal Factory. If there are other reasons for it to be relevant, we would request the defense to be a bit more specific on that, because so far we haven't heard anything more specific than what was on the summaries at the start. Now, also, they want to elicit a lot of evidence about Brigade 128. And at page 40, defense counsel stated that they want to elicit evidence about the movements of that brigade, and that everything that happened to that brigade is relevant. First of all, this is too general a statement. But then, when it is even more puzzling when then you take the position, as taken at page 39, that the accused was not a member of that brigade. So if the accused is not a member of that brigade, how is everything that happened to that brigade relevant? I think, Your Honor, we really need to be more specific. The allegations are very specific in terms of the time frame when they happen, in terms of the location, in terms of the accused's role and participation in these crimes. So, like the movement to Nashets, the relevance needs to be explained, Your Honor, if need be, through the defense providing additional information on what their theory of the case is, if that will enable everybody to understand better position. But as things stand now, Your Honors, the relevance, we maintain the submissions that we made at the beginning, and the defense hasn't shed any further light on the witnesses they want to call in relation to which we contested the relevance.
Thank you, Mr. Prosecutor. Victims' Counsel, you have the floor.
No, we have nothing to add, thank you.
Thank you. Defense Counsel, your turn.
Thank you, Your Honor. You understand the SPU want us to make our closing submissions at this stage or to put the burden of proof on us. We will not fall on that trap. We will explain once again. At the PTB and paragraph 9, the SPO alleged that Mr. Shala was part of the Brigade 128. We are bringing the Brigade 128, several members with several roles, to explain Pjetër Shala, I don't know him. Pjetër Shala, I heard about him afterwards. He wasn't with us. Is that not relevant to this case? We submit it is the heart of the case. More than the brigade, because the brigade was outside at moments. We explained the movement of that brigade. Mr. Shala was not part of that brigade, again. And we bring evidence from people who were stationed at the Kukes metal factory because they worked on the logistics. And those are relevant to say, I didn't see Shala. I saw Shala one day, he took a weapon. This is all in our opening statement, and he left to the front. I only saw him at the liberation. That is also more than relevant. And so the allegations of the SPO, which they failed to prove, we are bringing in front of your honors. I have given specific examples from DW 402 explaining clinics, things that the reality of this officer's building we heard about. We are bringing another witness, DW 405, and this is in the summary, who worked in the warehouse where we have heard that people were detained and slept there. And this person is there to explain. Some of them we briefly met, and because of their role, we want to see them and hear them. And that leads me to the international.
But before I give you the floor, John, just one further observation I would like to make, that witnesses 2 on the list, I'm following the numbering of the next 2, 3, 7, 9, and 13, that they all discuss Brigade 128, I know that. And I just want to note that we also evaluate, we assess, of course, also any kind of repetitiveness in allowing for a certain number of witnesses if we would do that. And I just want to bring that to your attention.
Thank you, Your Honor. Just briefly before Mr. Gillissen takes the floor, the 2 witnesses we have been able to contact, we ascertain they will come in the second block, are witnesses on the ranking number 3 and number 11. We explained to Your Honors that number 7, we have an issue with his health, and even we need to see him to assess his fitness to testify, but we have put him here in case he is fit and able to testify by video link. The other 2, that is number 2 in the list, and Your Honor said number 9.
2, 3, 7, and 9. I
3,
intend
7,
to say 11. But if I said 9, then I made a mistake, but I intended to say 11.
11 I just addressed,
Yes.
along with number 3, as well as number 7. For number 2, the most relevant element is that this is also another member of that brigade that doesn't know Pjetër Shala. So you have a number of members of that brigade who don't know Pjetër Shala. And this individual in particular, we put in it under this rule because we couldn't meet him and he refused to meet us. This is why we combine, technically we have 2 individuals who are able to come and they have very specific elements different from one another that they can bring to this trial. One, a little bit more information about the incident in Burel and the clinic, and the other one about the warehouse specifically where we had a role and we heard one of the witnesses speak about this name, this individual, and place him at the warehouse. I think it's TW410, if I'm not mistaken. And we are elucidating the evidence from the person that is mentioned there. So this is very specific to extra from what the general membership of brigade entails and their circuit. So we have some specific elements during the indictment period that they talk about either the clinic or the warehouse that we want to bring.
No. Good. Thank you. Mr. Gillissen, you have the floor.
Thank you very much, Johanna. To be very brief, I'm a little bit disappointed because I have the feeling that there is a willfulness to empty the case or to empty the possibility of the defense to present its case in the fact of my dear colleague from the SPO. A case is built. And you build a case because you make some choice in the evidence you have to show. But a judicial error is built with the same things. You make some choice not to show, not to talk about a lot of things. And you provide a very credible or a possible very credible image of the reality because you omit to show and to provide to the judges some part of the reality, but some very important part that change all of the things. And that's exactly what we would like to do, to make, to enable you to have a full picture of the things, of the reality. The truth, you know, the truth, all of us have an idea of the truth, of the reality. And there is a lot of flake. That's amazing, almost funny. To hear, oh, we have some problem with the date. We were obliged to hear events happening in 1990 8 during some hours, out of the delay of the indictment, of the period of the indictment. And we have some people who were in Cooks. They are able to provide you some very important information about the life in Cooks, the organization in Cooks, who were there, who were responsive or were not. We even have one man who provide us with movies. And movies about the life in the Cooks metal factory. We are able to see people who were there, who were not, and about a very important event, and we know we have, if we have to trust the witness of the prosecution, we have to know that during this event, the heads, the very big fishes of the UCK were in Cooks metal factory for some funerals during 3 days. We have these films, and we have these films. Why? Because the prosecutor has them. We saw these films, and we tried to collect a lot of information to know who is able to utter a speech, who is able to direct the operation, and so on. Not even one of the people who have to be there, if we trust the SPO witness, no one is on the picture. No one. So, of course, we are in the core of the case. What we would like is not that you trust us or you believe us. That's not the point. We are not children. That you have we could have all the elements in hand to decide. And I'm sure when you will have all the elements to decide, you will decide very fairly. I'm sure of that. And my guess is that you will consider that all the elements, the full picture, is not the one presented by the SPO. This is the different point of view. So, please, I would like to be able to obtain the possibility to ask some questions to these witnesses. We select them. We met a lot of persons. And you have to know, it's not a secret. Some people, and not 2 or 3, took contact with us because they wanted to be witnesses. And we refused them because we hate the way they use, and we fully understood that these people want to bring some elements in this case that there is no reason to be. So we make some choices, and it's a very, very delicate and complicated situation. So I'm sure you will enforce a real fair trial with the witness we propose. Of course, if some of them have to bring the same information or something like that, we will be the first to say it's too much, we withdraw with this witness. You have my words about that. So, thank you very much to hear me. Thank you.
Thank you, Defense Counsel. I trust that your remark with regard to that you are a little bit disappointed with regard to the willfulness to empty your case is not directed at the panel, because we are here to prepare your case.
Of course, I say in the position of my colleague of the SPO. I'm not used with that. I'm sorry to be said. Till now, I consider we have excellent relationships because the will is to find the truth. But now, really, I'm wondering why. They are afraid of what? To hear some people that we know that they are on the list of the brigade. They are on the list of the UCK. We know they were on the spot. They're afraid to hear these people? Afraid of what? Afraid of the reality? That's the question. Thank you very much.
Have we concluded the discussion on the content of the witnesses for now? Mr. Prosecutor?
Yes, Your Honors. We have no further submissions at this time.
Okay, thank you. Victims' Counsel?
Nothing to add. Thank you, Your Honor.
Okay, good. Very well. Then we continue with the next issue, and I urge the. No, let us go for a moment into private session. Just 2 minutes, and then we get back. Madam Court Officer, can we go into private session, please?
Your Honors, we are now in public session.
Thank you very much. Then we go to our next topic on the agenda, which are the expert witnesses, and more specifically witness 4 on the defense witness list, and it is witness free, defense witness free. We have taken note of the submissions by the SPO regarding the qualifications and the work experience of witness 3, which is filing 617, paragraph 3 and 4. Defense Counsel, do you wish to respond to the submissions made by the Specialist Prosecutor's Office? And would you be in a position to provide a more detailed CV of the expert? And if that is the case, by when? You have the floor.
Your Honor, don't have much to say other than we maintain that this expert is largely qualified to submit the expertise he has made and the report he has composed. If Your Honors want us to make full submissions, we can do it by writing. If Your Honors want us to have a more elaborate CV of the experience and the actions of these experts, we are happy to do that and ask them. We believe we have contacted the most qualified expert, probably in all Europe, about ballistics and the matters that he gives opinion on. This is a highly qualified expert from Britain who works for years, decades, on very elaborate and complex issues related to weapons and ballistics and everything related to weaponry. So if Your Honors want us to make an exchange in writing, we can do that. If a more elaborate CV is required, we're happy to contact them and give us a number of extra information and or their writings and everything. We are happy to do that.
Okay. Now, thank you. I hear it. Yes, indeed, thank you. And something about the time frame?
What we can promise is that we can ask today. We are still in August, unfortunately, and when we addressed them through the institute that we are dealing with, we didn't have in the just before the recess until now, the responses were not very quick because of the situation. And this is one of the reasons we have also provided from the beginning a question about availability to this expert for the last block to make sure everything is set and no surprises are encountered. But of course, we can send the questions today, and as soon as we have them, we can provide them to everyone, even as courtesy.
Thank you very much. And with regard to setting this witness, if it would be, following the procedure we always do, we could also try not to leave it for the last block, depending on how quick things go. Things go. I mean, it's not set in stone, I would say. Very well. Specialist Prosecution's Office, what can I give the floor? If any submissions...
Is this on this matter? We
Yes.
don't have any submissions, Your
Okay,
Honor.
very well, clear. Victims' Counsel, is there anything you would like to say in this regard?
No, thank you.
Thank you. Good. We have taken note of your submissions, and we will follow up also tomorrow on this. The next topic concerns the applications under Rule 153, 154 and 155 of the rules. We have seen some changes in this respect. Defense Counsel, do you have anything to add in respect to your written submissions?
Not really, Your Honor, but the assessment of the rules and the way it should proceed is the most accurate one is to proceed first with Rule 153 because of lack of dealing with the acts and conducts. That is the position of the defense. However, we are conscious of the interplay between the rules. We are happy, and this is the statement that we want to say, that we are happy if these individuals are called for cross-examination or for everything, if that's the wish of the panel. And we already put the notice that since we didn't have any contact with them, or they refused contact from the outset, despite all efforts, then we will have to come to Your Honors to request summons so they can appear. And that's why, I mean, as soon as we have any decisions on that, we can place them in the blocks that we have. Most of them don't require extensive time if they are called, but since we consider that they don't concern acts and conducts, the starting point should be the Rule 153. Thank you.
Thank you, Defense Counsel. Mr. Prosecutor or Madam Prosecutor, would you like to raise anything in this regard?
Yes, Your Honor, very briefly. My colleague has made some comments as to the relevance of some of the proposed witnesses, and some of these include witnesses proposed under Rule 153, and these include, for example, 3881 or 4454. As for the other witnesses proposed under Rule 153, we object to their introduction of their evidence under this rule, but we will, of course, respond to the defense submissions when they are filed. And similar observation with regard to 4751, which is proposed under 155. Again, has been said that the relevance is unclear to us. But we hope to get more clarity on the Rule 155 application, to which we will respond in due course. Thank you.
Thank you. Victims' Counsel, would you like to make any observations?
No, thank you, Your Honor.
Thank you. No second round necessary, yeah? No. Very well. The point you touched upon, Defense Counsel, with regard to the summons, that is the next item on the agenda. The summons of witnesses pursuant to Rule 121, Paragraph 3 of the rules, we understand, Defense Counsel, that there are 8 of the witnesses on your list that have to refuse to meet with you, or you have had no further contact with them. And for the record, I mention witness 4441. Yes. 4280. 4440. 2517. Witness 3881. Witness 2549. Witness 4405 and witness 4454. we noted that you intend to file a Rule 121, Paragraph 3 request for witness 2517 and for witness 2549, and for the rest you intend to make the 153 requests. And it is now my understanding, Defense Counsel, that if they would be allowed and if you would file a 153 request and that would be rejected, you will be requesting these witnesses to be summoned by the panel. Is my understanding, just for reasons of clarity, correct?
Yes, Your Honor, and it's a little bit more subtle than that. Even if it is accepted, but Your Honors require them for cross-examination, so we go into the 154 under paragraph 3, I believe, then still for the cross-examination alone, that will require also the request to summon them. So we don't have hold of these individuals, except for one that I'll come to at the end of the submission, that we met before and then refused. The others, we don't have contact with them. So if they are required in part or in full to come to the courtroom or video link or any kind of live testimony, we will have to make that request for Your Honors.
Okay. Okay. Now, as is foreseen according to Rule 121, Paragraph 3 of the rules, it's up to the defense to call its witnesses, of course, and you are responsible for that. And the panel would like to know what efforts you have made to contact these witnesses. That's my first point. And the second point, which is not so much a question as more an observation, is the requirement, one of the requirements is that if we decide to summon these witnesses, it's your responsibility to provide us with the necessary information identifying the witness and their place of residence. I want to make that clear because we cannot go running around the globe for the witnesses. And as you have said yourself, it's not that they are all in Kosovo. And by reading the statements, we already noticed that some of them are not in Kosovo. So. Yes, if you could give us some further clarifications as to what efforts you have been, and I would like to, if it's possible, that we are kind of specific.
Thank you, Your Honor. We believe it's less complex than going throughout the globe because, as Your Honor see, most of them have been in contact with the SPO, so we might have where to find those data of personal data, but I'll go through the individuals with the steps taken. So starting with W04454, who is number 2, I think, the second on our list, we requested the contact details from the SPO, and it was the SPO helpfully contacted them to ask whether they accept to enter into contact with the defense, and that was rejected from that individual. It is the same for W04405, the same for W04454, which I just mentioned.
Not too quick. 4, yes. So it was rejected, so they didn't want to enter into contact, but apparently there is an address. Because I'm interested in both your efforts to contact them, but also to know where we stand as it comes to information regarding their place of residence, to see the level of complexity we are at.
Yes, Your Honor. Then I'll go one by one and explain the situation for each one. So for the 2 on the list that I just mentioned, W04454, SPO contacted those witnesses of theirs initially because they had their information, and this individual refused to share their contact details with us. We have made efforts to locate them, to try again in a different manner, and it was unsuccessful. We had absolutely no contact with this individual. All we have is his statement and the information that the SPO took a statement from them that if a summons becomes applicable, maybe we will need to request from the SPO to share the contact details that might help us make the request for your honors and for your honors to summon them. That is the first one. Turn into W04405. That is the fifth on our list. It is the same, declined to share his contacts details with us after requesting it from the SPO. However, there is one slight glimmer of hope with him. We have established some indirect contact with acquaintances of his, and we are waiting and hoping for a response message, same way we did with the SPO, whether this individual could accept to meet us, but we had no response yet. It was a bit difficult because there are two people with this name in the KLA at the time of the war. One was high commander and another one was a soldier, and this is the right one. But we don't have a response yet. If we have a contact, we succeed to contact this individual, maybe then we try to bring him ourselves with our efforts, but this is not the situation that we can report at this stage. Turn into, I will deal with W04441 and W04440 together. So, 440, we have met once. This individual, I'm conscious we are in public, we have met once to understand that this person cannot cooperate with us. There is mention of health problems, and there is unwillingness to discuss that. The only information is the one that is in the statement. Never been to Cooks, never been with any role in Cooks. But we have a clear refusal to testify. And this is one of the reasons we want the statement for that discrete point we want to establish through the statement, which is very short. And this is the same for the other individual, that is W04441. We had only indirect contact because this is a similar setting, let's say, similar facts, indirect through the first witness. We are talking about 4440, which led us to hope to meet this individual, and after several efforts, contacts, some excuses, of course, and then there was a clear rejection to meet us. So this is an individual that we didn't meet, but for a similar reason, we want their statements in, or to summon them eventually to come and testify about these points. Very discrete points. We don't need that much more from them. Coming back to another individual, if your honors want.
Yes.
Okay.
Yes, thank you.
So W04280, that would be the 9th in our list. We requested it from the SPO, and the request was rejected to share contact details with us, and despite all efforts, we could not locate this individual. We believe this individual is in Kosovo, but we don't have further details, but we believe the SPO could be in a better position to have official details of where to address any communication to this individual officially. Regarding, probably deal with the three internationals together. We have attempted to contact at least one of them through private details that we found that is not related to the official duty of this individual. And that was in November of 2022, and to this date we didn't have any response. When we requested the details from the SPO, we received a clear indication that we are forbidden from taking contact with them due to the circumstances of their work. I think we are on the same page on that. And then I would come to the Rule 155 individual, that is W04751.
Okay, but
Yes.
I would never, the panel would never ask you to contact this person. So I don't think it's necessary to elaborate on that, unless.
Yeah, just-
okay.
Just to say that we come to understand that this has become a Rule 155. At the time we tried the steps.
Okay.
That's all we wanted to
Okay.
say, of course. Of course.
Good. Thank you. Are those the submissions you wanted to make with regard to the efforts you made to contact these witnesses?
Your Honor, unless I missed one of the individuals,
1, 2,
those
3,
are
4,
in the list
5,
that we have.
8, 9. I think it's okay. Very well. Then I will give the floor to the prosecution service. Would you like to comment?
Just to clarify the record, we did not. I'm sure that the defense counsel didn't mean to misstate our communications, but our indication is that, with regard to international, it's not forbidden from contacting them. Is that we're not at liberty to share their contact details due to their position, and they should have gone through the authorities. They should have requested the contact details to the authorities for which these individuals work and under which they're employed.
Okay, thank you.
Apologies, yes, they were not allowed to make direct contacts, and so we had no other means of contacting.
But you have not contacted the authorities, defense counsel. You have not contacted authorities for which they work? Or you could do that?
This is what I'm trying to ascertain, whether we sent correspondence to the entity. Just a second, Your Honor.
Thank you. Victims' counsel, in the meantime, may I give you the floor for any observations?
No, we've nothing to add. Thank you, Your Honor.
Thank you.
Yes, Your Honor. I'm told that we made one email contact on personal contact details with one of them, who is W02517. We have found a phone number for another one, which I'm not sure which one of the two others, unsuccessful, but we have not contacted directly the entity.
Yeah, I leave it to you as a suggestion to obtain further information to contact them. But let us first assess how we proceed with these witnesses. Yes, a question for the Special Prosecutor's Office. If I understand rightly, for some of these witnesses, the SPSO might be in a position to share, if it would come to summons, share information regarding their place of residence and further addresses?
Your Honor, does Your Honor mean not the three international? We're talking about the other ones. Yes, we would be in a position to share, if required by the panel, additional information which may be subject to standard reductions at the moment in their statements, and perhaps more. Of course, we will cooperate to the best of our abilities.
Very well, thank you. For now, I think we can conclude this. The point the panel wanted to make for now is the importance that the defense obtains or comes with the place of residence and the addresses of the witnesses they want to call. But I think that point has been sufficiently made, and we have heard about if there's any possibility the SPO can assist, it will.
One further point, Your Honor, if it comes to a summons and there is an impediment to share with us the details, as long as those details are obtained by the panel to issue the summons and these individuals finally appear here, we don't need to know it. We just need these individuals, if they are summoned, to come and appear. If there is an impediment for us to know those details, we're happy with that. All we need is that they somehow are reachable, because despite all efforts, we could not ascertain those details ourselves. That's all I wanted to make sure of.
Okay, thank you. Next topic is potential request to examine witnesses via video conference or away from the trial venue. We have taken note of your submissions, and if there's nothing to add, we can move on to the next topic. No, very well, thank you. I saw all parties and victims' counsel nodding that it was not necessary. Thank you. Very well. The point 11, assurances against self-incrimination, is the next item pursuant to Rule 151, paragraph 3 of the rules. Also for this topic, Defense Counsel, we have taken note of your submissions, and if there's nothing to add in this respect, we can move on. Yes, I see that there's nothing to add, and very well. The SPO would like to make a submission. Please, you have the floor, Madam Prosecutor.
Thank you, Your Honors. Just briefly, again, it's difficult to comment on this point without more information on a number of witnesses. However, it is already apparent from our records and that we have reviewed that witness 4280 might require such assurances. So this is just something to be put on the record for future reference. Thank you.
Thank you. That is noted. Victims' Counsel, would you like to add something?
No, thank you, Your Honor.
Thank you. Yes, the next item concerns the objections by the SPO and Victims' Counsel to the admissibility of the non-oral evidence. The defense intends to present at trial. You have taken note of your submissions, both with regard to what the prosecutor has brought and Victims' Counsel. So, Mr. Prosecutor, is there anything you would like to add? And I see that you're puzzled. I didn't want to say that you are objecting. It's on the topic of the admissibility. Okay. Yes? No. As I was saying, I realized that it was could be interpreted in two ways.
Yes, nothing to add what is already in our written submissions, Your Honor.
Thank you. Victims' Counsel.
No, nothing to add to what we've submitted in writing. Thank you.
Thank you. Good. Defense Counsel, would you like to raise anything in this regard?
Thank you, Your Honor. Thank you.
Very well. The last item on the... no, not the last. We have still one item, and that is with regard to the protective measures for the proposed witnesses. We've seen, Defense Counsel, that you have not requested any protective measures for the time being. Is there anything you would like to add in this respect?
Just a precision for the record that no protective measures requested from those who were able to meet. The question might be posed if there is a summons for people we didn't contact, then the question has to be asked to them at that point, and then we can work that out. So those we met, and I'm mainly talking about the DW4s, and the two that we met that were originally SPO witnesses, no protective measures are requested. However, the other ones, the question, we cannot speak for them for now.
Thank you.
Thank you.
Important addition, thank you. Is there anything to say from the part of the Specialist Prosecutor's Office?
No comments on this point, thank you.
Thank you. Victims Counsel, have you any observations?
No, thank you, Your Honour.
Thank you. Very well. Then we go to the last topic on the agenda, and that was the request of the defense to amend the exhibit list. This is filing 618, paragraph 29 till 32. Is there anything you would like to add to your written submissions, Defense Counsel?
No, Your Honor. I think we have set out specifically the documents and the reasons behind it, and if that's satisfactory for Your Honors, we will just stick to those. Thank you.
Madam Prosecutor or Mr. Prosecutor?
Your Honor, we've already made remarks on the relevance of these witnesses, nothing to add at this time.
Yeah. We noted them. Thank you. Victims Counsel?
No, nothing to add. Thank you.
Now, that was the last item on our agenda. Do the parties and Victims Counsel have any other issue they think it's necessary to discuss at this moment in time?
Not from us, Your Honor.
Very well.
Nor from me, thank you.
Thank you.
Nothing from our side either. Thank you, Your Honor.
Thank you very much. Then I thank the parties and Victims Counsel for their attendance and participation today. And I also want to thank security in the audiovisual booth and the stenographer and our interpreters for their assistance today. Oops.
I'm sorry, Your Honor. I thought that we were going to address orally the reply to the defense response to our motion for admission of evidence relating to the accused.
I was not aware that the Specialist Prosecutor's Office wanted to do that, because I left it open if it would be orally or in writing, and I had not heard anything. So but before we proceed to adjourn the hearing till tomorrow, if you could reply to that, I will give you, of course, the floor. Sorry for being not clear on this.
No, not sorry. We should have stated our intention to do so. We thought it would be more efficient, and upon Your Honor's invitation to consider that possibility, we think that it's more efficient to make a short oral reply, which we're prepared to do now.
Very well. I think it's a very good idea. So please, Mr. Prosecutor, you have the floor. Yes. And for this point, do we need to go into private session?
Yeah. Yes, Your Honor, we do.
It was kind of a Socratic question, yes. Madame Court Officer, can we go into private session, please?
Your Honors, we are now in public session.
Thank you, Madam Court Officer. So tomorrow we will have another hearing starting at 2:30. Then the panel will be giving some orders, issuing some directions regarding the defense case, and then we will adjourn for, we will see for when. Very well, the hearing is adjourned.
All rise.